Meeting of Haverford Township Planning Commission is now called to order. It is meeting of August 10th, 2023. Margie, could you call the roll, please?
Mr. Shannon.
Present.
Ms. Dobbs. Present. Mr. Garrett.
Present.
Mr. Capuzzi.
Present.
Mr. Fiordemondo.
Present.
Mr. Montresor. Ms. Phillips.
We stand for the salute to the flag.
Pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
First item on the agenda is the 104 and 108 Allgates Drive, requesting approval for a lot line change, which we understand has been approved by the zoning hearing board, or the variance has been approved by the zoning hearing board.
That is
Could you
correct.
state your name and
Sure.
address?
William Dion with the law firm of Silverang, Rosenzweig, and Holtzman here on behalf of the grants this evening.
And in part of your presentation, I assume you're going to explain some of the background?
Absolutely.
So we understand what this transaction is
I will
about.
set the table for you.
Thank you.
So just briefly, I represent the Grants, Michelle and Ed Grant, who own 104 Allgates Drive, or Allgates Road. And they are the owner of 104, but they are the equitable owner of a portion of 108 Allgates Drive. Mr. Latowski, unfortunately, the Grants could not be here this evening. They're out of town on vacation. But Mr. Latowski, who is the owner of 108 Allgates Drive, who is the seller of the portion to the Grants, is here this evening, and he is here obviously in favor of the application. This whole matter came where the Latowskis and the Grants had done various improvements to the properties over the year, in particular building a pool. There was a fence there. They obtained the permits for the pool. And at one point, Mr. Latowski performed a survey on the property only to discover that the fence that everyone thought was the common property line was in fact not the common property line. So at that time, the Latowskis and Grants entered into an agreement of sale to basically shift the property line slightly so that all the physical improvements that were out there today would be on the respective person's property. Had some meetings with township staff and realized what seems simple in paper is not that simple to accomplish. The previous approvals for this development had created some existing nonconformities, in particular with regard to impervious coverage. So a special exception was needed to expand an existing nonconformity because as we shifted the lot line, we in fact made the Grants property larger and their denominator larger. So in theory, their impervious coverage went down. But because the Latowski's property got smaller, and their impervious coverage stayed the same, but their denominator got smaller, bless you, their impervious coverage went up. So we went in front of the zoning hearing board. We did obtain that special exception to expand the existing nonconformity as it relates to the impervious coverage. That was granted, and that really puts us in front of this board this evening seeking approval for the lot line change to take one step closer to effectuating this. So it's approximately 1,520 odd square feet that is changing. We did receive a review letter from Mr. Faulkner dated August 8th, 2023. The review comments are fairly straightforward, and we did provide updated plans addressing those comments. They're all will complies. We did reference the side yard setbacks are now indicated on the plan. We did add the signature block. We also indicate that a monument would be located at the corner of the right-of-way of Allgates Drive. And we also added a note to the plan that there are no improvements proposed as part of this lot line change. It is literally an administrative exercise so that we can record this plan ultimately and deed from the Latowskis to the Grants this sliver of land so everyone can then know they own the portion of the property that the physical improvements and the fence have seemed to represent for years. So that's it in a nutshell. I don't know. I do have our civil engineer this evening. If you have any questions, Mr. Latowski, I'm sure would answer any questions if you have also.
Are there any other, you say there's no present improvements. Are there any contemplated or intended improvements?
There's no contemplated improvements. This is the improvements that are there today, the fence, the pool, the landscaping, that is all there. This lot line change will get it to really run where the fence is. So everyone who thought, all the setbacks when the pool was built was taken off the fence, and people just made an error, and it just kind of steamrolled till today. No, do you know, Mr. Latowski, how long the fence is there?
I'm sorry,
Curious how long the fence has been there that everyone's been using as the common property line.
1986, when I moved in. I'm the original owner of, the Old Gates development. Lived behind the mansion, I'm the original owner. Put the fence in 86.
So,
86, properties.
yep. Correct. And unfortunately, and to no one's fault, when the permits were pulled, because Mr. Grant did pull the permits for the pool, it wasn't uncovered then either. So this issue that was maybe a little smaller has only gotten bigger because of the additional improvements that were put in, I don't even know, maybe 5-6 years ago. So it's been a little while, and we kind of just stumbled over this as Mr. Latowski did a survey for a completely unrelated reason, but we then uncovered this problem. So everyone's working together to try to solve it and have the paperwork and the deeds reflect what everyone believed they owned.
I have a couple. I'd like to see a copy of the zoning order put on the plan,
Absolutely.
okay?
Sure.
And also the zoning table for the SRD district. For some reason, it does not list the allowable impervious coverage in that district, so I'd like that added also.
Absolutely.
And finally, subdivision plans have to be sealed by a professional professional land surveyor. So before the plans get recorded, we have to make sure that a registered professional land surveyor seals the plans.
Understood. Once we have all the approvals, we'll make sure that we provide the appropriately plans for recording, but we will make it's a good point to add the zoning decision. We haven't received it yet, but we'll add the reference to it.
And one other question, for some reason, we got a copy of the agreement of sale, and there's an Exhibit A which talks about, I guess, a verbal guidance for how this new property line is supposed to lay out. I'm assuming the location of the proposed property line matches the Exhibit A requirements?
Well, it is, and just for your, Exhibit A was an attempt to verbally describe it, so what we've done is we've gone out with the surveyor, staked it, and the Grants and Latowskis agreed what it would be. So now we have actual legal descriptions to
Right.
back that up, yes.
Super. That's all I have.
Yes. Is it the river rocks around the pool? I would say, well, unfortunately with the grant's not here, I've been there, and I would say they're probably more decorative than anything else. They might serve some runoff purpose, but they seem to me, when I was there, to be more decorative in nature. I guess I can have the civil engineer attempt to answer it. I guess the only good thing is, since the pool's been there for a number of years, there have been no issues with runoff, so it seems to be operating fine, but I can give the engineer, if you want, a more technical answer, and he can probably speak to where he thinks the water is actually running based on the topography.
I was concerned about that. That's
Okay, sure. Would you like Mr.?
If it's worth explaining, or if it is decorative and there isn't any water that's being dumped on someone else's property, I was just curious if is it contained?
That just appears to be decorative. There's a swale that runs between the two properties, so all the runoff will be going to the system.
Okay, that's all. Thank you.
Thank you.
Would the engineer please just state your name for the record?
Michael Rakosny, a civil engineer from Site Engineering.
Thank you. Any other question?
Yes, I have a few. So Mr. Capuzzi asked if the maximum impervious coverage for the special district the special residential development district be put on the plans, what is the maximum impervious there?
I believe it's the same as the underlying zoning district.
So 30%?
Yes, I don't have it in front of me, but if I recall correctly, what it allows you to do is to, it's basically an old-fashioned, I'm trying to think of the right term, where you can cluster your development. So really, you can have open space somewhere else. So that's how a lot of these lots were developed under that zoning, but now they're existing nonconformities because some lots had more than the 30% and some had less.
As pre-existing conditions?
Yes. So that's why we ultimately sought a special exception to expand the nonconformity because the Latowski's lot exceeded the permitted impervious coverage. And when we took land away, it was only going to increase that nonconformity.
In addition, our impervious surface ordinance wasn't adopted until 1993. This development predates that.
Okay, perfect. Thank you for the clarification. That was going to be my next line of questioning, so we'll just preempt that. But I do have a question for Kelly. What is the minimum setback for pools?
10 feet.
Okay, so then both of these properties would be in conformance with that, and that's to the edge of water? Okay. Do we have setbacks for the patio area around the pools?
We don't.
Okay. So considering everything is pre-existing, non-conforming in regards to the impervious cover, I don't have any substantive concerns about this. Obviously, the one property at 104 will have kind of gain some additional allowances for future impervious cover. And then the 108 property is still limited on adding additional impervious cover. But all this to say, I work as a zoning officer in a different municipality, and I see this all the time where people don't get surveys of their properties, and then they just use like local landmarks
Oh,
and
yeah.
property lines.
Yep, we eyeball it.
And it causes problems down the line, so this is just a lesson as to why you should survey your property before putting
The
in
good
pools.
news
But
is the Latowskis and the Grants have a good relationship, so it's
That's-
not turned
that's
into an ugly
good.
divorce, let's put it that way.
that's good. Okay, no further questions, thank you.
For their sake, I'm very glad they did, because I have observed the same kinds of problems
It can be
just
very,
mentioned, and it can take, the one I'm looking at right now has been about 8 years, and I won't provide any of the gory details.
no, it has been, to have both of them trying to solve it has made this process dramatically easier than it could have been. I've been involved in some nightmares myself, so it's a compliment to how well the neighbors get along.
Great.
I have one question. Does the increase in the property size for 104 All Gates then also increase the allowable maximum impervious coverage?
Technically, it would, because the denominator is now bigger. So if it allowed, I don't even know, if it allowed, let's say 23,000 square feet of impervious coverage, it might allow 23,400 square feet now, because in theory, and not in theory, the lot denominator, the size of the lot just got a little bit bigger.
So I understand the 30% calculation, but I'm wondering if it's not unreasonable to then continue to burden these properties by having even further increased impervious coverage in the long term. Should the maximum allowable impervious coverage be held at the amount available at the smaller property size?
Well, I guess 108 will be capped because it's an existing nonconformity. They'd have to come in for another special exception if they chose to put anything additional. And I guess 104, in theory, might have some additional square footage that they could do. So, in my preference would be to not then try to create even more unique zoning criteria for the lots. It seems to get confusing as years go on. So I understand the comment, but I would prefer to just have it stay under the existing ordinance versus having another asterisk next to these in years to come.
We're increasing the amount of nonconformance in the 108, and we're increasing the allowable impervious in the neighboring property, so that the total between these two properties that we're reviewing, now the impervious coverage is net increased.
Well, no, in theory, it stays the same. I mean, because you've decreased one, you've increased the other. I mean, it's, look,
No, we haven't decreased the other because you're already far over the 30% maximum impervious coverage on the other site.
I understand your point. I just think it will lead to future confusion. So if the grants, I don't think they're at the cap today. You know, I don't
They're
think-
not.
Right, so in theory,
But I don't think their cap should increase.
okay, I would respectfully disagree, but I understand your comment.
I will say, though, the lot line change cures a non-conforming, because the pool, as built, was built in violation of the setbacks, because that, if it's a 10-foot setback, then the pool sits, what is the setback from the existing lot line of
I'd
the
have to
pool
ask
as
Mike, but
built?
it is a violation.
Right.
Yes. And that's why I pointed out, we did pull a permit for it, but everyone was mistakenly using the fence.
Right.
Yeah.
I mean, ultimately, it's the property owner's responsibility for knowing where their lot
Yeah,
lines are.
I know, yep.
So the setback as it is now is going through the 5 feet. Increasing it to the 10 feet.
Right, yeah, so I understand the impervious cover, and we were talking about that before the meeting, but this does cure another violation in ensuring that that pool does meet setbacks. So while there's good relationships now with the property owners, in the future, if those neighbors change and they don't have as good of a relationship, then at least the minimum setbacks are being observed.
Hearing no further comments, is there a motion from are there any comments from the people here? Hearing none, is there a motion?
I'll make a motion to recommend approval of the minor subdivision plan for 104, 108 All Gates Drive on the condition that the comments from Mr. Capuzzi be incorporated into the final approved plan, and any outstanding comments from our township engineer be met prior to final plan adoption.
I'll second the motion.
Motion seconded, all in favor?
Aye.
Roll call. Do a roll call.
Margie, would you call the roll, please? In favor, yes.
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 Thank you very much, I appreciate your time.
Next item on the agenda is the review of the minutes of the June 8th, 2023 meeting. I believe everyone has gotten a copy. Are there any comments or changes or concerns about the minutes? No?
I'll make a motion, we approve the minutes from our June meeting as presented.
Thank you. I'll second. All in favor? Please say aye.
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 Any opposed? Hearing none, the minutes are approved. Is there any new business or anything anybody wants to raise that we should be aware of tonight? Hearing none, I'll entertain a motion to adjourn.
So move.
Second.
All in favor? Thank you all. We're adjourned.